including a parent can even make a loan to their child secured by a mortgage without going through some of these stupid steps, because some lending regulation got passed that didn't have a loophole for, or an exception for anything private. Seller financing is generally a catastrophe. I don't think I've ever had a client who has held a mortgage that's been a happy person. Once in a while it gets paid without an issue, but some kinds of properties, they just, I can only get a mortgage for so much. Can you please hold paper for the other $100,000 behind the $700,000 first mortgage?
We get asked all the time down here. We hold 50% of. We'll give you full price. But you're going to hold a 50% note in a second.
In a second?
Yeah. They throw it out all the time.
See, if it was a first, okay, so
sure.
Priority. You have a property ownership. You can have a first mortgage. The first mortgage is recorded against the property. Second mortgage, nothing magical. It's the second mortgage gets recorded against the property. The first mortgage, if it doesn't get paid, can wipe out the second mortgage. So, which means that the second mortgage holder is not in a safe position. Now, if you were coming to me and you said a 50% first mortgage, 50% loan to value ratio, remember before we were talking about a 70% loan to value ratio, I don't like purchase money mortgages because you have to enforce them, and it makes people unhappy. But some people have enough money and they don't care, they don't need the money, and they will do it because if they can get 6 or 7% or whatever it is on a mortgage, and they can get 2% in the bank, they would rather have the additional income coming in. There's also some tax advantages if you take an installment sale. You don't have to report all the gain the first year, but there's risks.
The percentages they offer is usually sub-prime.
Usually, in a real purchase money mortgage, in most situations, it's a little higher.
It should be.
Well, it is. It generally is because you're recognizing that there's risk involved.
Maybe subordinate debt. So
That's
the
second.
second one would be?
The second mortgage is much higher risk.
We presented that we rattle on scams.
I wouldn't go that far. Okay, so I just want to go back. Now we've gone top to bottom in the form, and I want to just see if there's anything I've glossed over that I need to go back and without getting into too much extra detail. Now that we've gone through some of the definitions and what some of the things mean. Oh, you know what? I didn't see. I missed something. Back on the first page where we were talking about the time computations and effective date and things. There's a sentence in bold at the end of that third paragraph. Time is of the essence of this contract. That means that when the closing date comes, the closing date has arrived. And you can't say, I'll be back in 3 days. Time is of the essence means, I mean it, I'm serious about the date. You can strike it, and that's why you also notice when I talked about that cure period paragraph back in the contract, there was an exception. Remember that notice of a 5-day cure period I mentioned? There was an exception for closing. Because time is of the essence, you have to close. You know you have to close, you know the date you have to close. So that's what it means. That's what time is of the essence. Oh, I wanted to mention, we talked about a pre-qualification letter for financing. In a normal transaction, you're going to see somebody come to you with their pre-qualification from Bank of America, SunTrust, Wells Fargo, something like that, that they, regular recognized bank. And it's going to be for a normal amount of money. Like in my example, I'm using $1 million purchase price and a $700,000 mortgage, and that's not out of the ordinary. However, if you're talking about a larger transaction, like adding 2 more zeros, and let's say you're talking about a $100 million shopping center or office complex or something like that, and a $70 million mortgage, and the pre-qualification letter comes from a bank you've never heard of, do some diligence. I had one come in, and it was some, astronomical numbers. And I got a letter from a bank in either Minnesota.
Bangladesh.
No, it was either Minnesota, North Dakota, something like that. No, that's a real bank. That's a real bank. That is a real bank. So I went, again, we have the resources, we have the computers. I went on the FDIC website, and if this letter, this pre-approval letter that said that so-and-so has on deposit all this money with the bank, if it were true, it was about 70% of the capital of the bank. It's easy. It's very easy. I wanted to go back for a second.
What about foreign sources of money?
Say it?
Foreign sources of money. They like a loan from Russia or something.
There's nothing wrong with it if the money makes it to the closing table.
Yeah, but as a proof of funds.
Prove it. I mean, as a seller or as somebody evaluating the possibility of performance, whether it's coming from a North Dakota bank or First National Bank in Leningrad, how are you going to be sure that that money is real?
But if it says Leningrad, you probably know it's not real.
Why?
It doesn't exist anymore. It's called something like St. Petersburg.
Oh, it's back to St. Petersburg. Good catch. Good catch. Thank you. But you see my point. So it could come from a foreign bank, and it could be perfectly legitimate. How do you check it out? I don't know. People, the more likely if it's cash, they're going to come with a brokerage statement. I see that all the time from, Merrill Lynch or bank, whatever it is.
What's it like? Is it just a letter, or is it like a certificate? Or?
Oh, it's a letter. Or someone will just, a less sophisticated person will actually hand you a copy of their brokerage statement and say, look, I have all this money. Check
The account number and everything.
Well, yeah, but remember, if you're, and I understand the security issues and so on, but if you're trying to get someone to accept a contract for $10 million, you're not going to worry so much in the closeness of the transaction of your account number being on there, because nothing's going to happen unless it's passing through disreputable hands.
I mark it out. I just think it's
Sure.
just too much
And there's nothing wrong with
information to
it.
give to everybody.
There's nothing wrong with marking out some or all of it, as long as you know that
This
it's
is really
real.
Merrill Lynch.
Right. I'm just flipping back, there was something I wanted to tell you on the title, to kind of explain the title commitment and title policy and the examination, because you are relying on third-party information, and I glossed over the concept of exceptions in the title policy, and I didn't discuss what that really meant, although I intended to talk about title in much more detail. But when you present it with a title commitment or title policy, and the second part of it has those exceptions as to what's not covered, that's exactly what that says. We will not insure against loss or damage by any of the following listed things. Now that's where you're going to find your declaration of restrictions. That's where you're going to find any of the things that are in the public records that affect the property. And it's basically a statement that's saying, you better look at this document and be comfortable with this document, because if there's a lien that arises because it's a property owners association, and then of course you have to deal with that, or if there's a restriction on the use of the property, we're not covering that exception.
So you said temporarily you don't have to go and look at abstracts anymore, right?
Right.
So when a title insurance company underwrites that title, is that underwriting then stored somewhere publicly?
No, but okay, so let me tell you what the difference is. In examining the old-fashioned way of examining an abstract of title, basically what you were doing was you were going back into the public records all the way to the year 1, and looking at every document relating to the property itself. And the abstract, hopefully if it was done correctly, as it narrowed down, because there's documents that deal with larger tracts of property, but as it narrowed down to your specific property, it only dealt with the specific property you were looking at. It was up to the examiner, which back in the day was the lawyer, the real estate lawyer, to determine whether a particular document affected the property, was still valid, had an adverse effect, and what its effect was, and to explain that document to the buyer. The title insurance underwriter is doing the same thing based upon the information that they maintain, and they're saying that we will cover the title to the property, ensure that the title to your property is fine, except for these things that we list. So all you have to look at is the things that are listed.
So then the information then is proprietarily kept for, like you mentioned, like for the exceptions, like they've gone through, done the due diligence on
Right.
it, and they underwrite based on that, and it stays
Right.
in-house.
But what they're looking at is documents in the public records.
Right.
But they're making a determination whether a particular document affects the property or not. And they miss things.
Well, the reason I'm asking is because then it's say, that's company A, right, they've underwritten this, it's changing, hands, company B is doing the new.
Right?
Where does company B go if company A is not sharing the information?
Correct.
Anderson versus-
Yeah, but there's two answers to that question. Number one is they're entitled to rely on company A's policy and go forward from there.
Okay.
Okay? And they're entitled to, there's treaties between the companies as to what they're allowed to rely upon and what the effect of certain clouds are and who's going to take care of what. So they don't have to go back and do the search all the way back into history again. That's one thing. And hopefully when it's done that way, and you know you're okay. However, they don't always do that. They may still go back and say, yeah, but we want to go back and look at. And then what happens is when it's a different underwriter that gets involved, the different underwriter will come up with other issues that were not raised the first time. And that causes a seller headaches. And then sometimes if it's a bad enough issue, they'll go back to, they'll make a claim. It's what's called, if there's a loss, if it's causing them a problem, they go back to whoever insured their title when they bought it and say, hey, you missed this. Now, that being said, you're a little bit ahead, but it's okay. A title insurance policy is a snapshot on a motion picture. That means that it is only the state of your title as a given point in time. As a seller, it's insuring your title as the date of the deed that you received when you bought the property. And that's the date that they're looking at what's in the public record. If something's happened after that, because you've done something, they're not responsible for that. You have to take care of that at the next round.
But if they missed a restriction or a covenant, do they cover themselves for errors and omissions?
More than that, they cover for the value of the property. But just missing a restriction, what's your damage? Remember, I mentioned in talking about title insurance that it's pay or defend. But just because they've missed something, unless it adversely affects the value of the property or makes your title unmarketable, which means that it doesn't pass the basic standards of good title, because, for example, you can't use it. Okay, let's go back to that with my old McDonald's I was talking about. If that's not disclosed, and you buy the property, and now you go and you see you've bought this property that's got grease traps and stoves and other kinds of equipment to run a restaurant, and all of a sudden you're going down and you bought it, you closed, you're moving forward, and now McDonald's comes and sues you because you're selling chicken sandwiches, you have real damages. Now you go back and make a claim on the title policy, and they can either, and they're going to pay you, and if it could be, they're going to pay you the diminished value of the property because now you can't lease it to a whole range of tenants that you would have been able to. Or sometimes if it's bad enough, there's what's called a failure of title, and then they write you the face amount of your policy, they take the title, and you get your money back.
So is it the state that maintains
No.
The definition of good title?
No. No, it's Florida bar. But good question, because there's two issues. What I will review and say is marketable title, because, by being an experienced title examiner and knowing what the standards are, is one thing, versus what a title insurance underwriter is willing to underwrite, because what they're doing, like any other insurance underwriter, is they're agreeing to accept risk. How much risk are they willing to take? What is the risk that something is going to happen to this property in the future based upon what's happened in the past? And that becomes a problem because, to get to a closing, sometimes there'll be some slightly technical thing. Real estate, as you can imagine, is very technical, and title is very technical. There can be some very technical thing that I'll look at it and I'll say, well, this isn't really a problem. Yes, it wasn't done exactly right, and this person should have joined in that or something like that, but there's no harm because, whatever the legal explanation is, that underwriter can look and say, yeah, but if we agree with you, and the person that was omitted comes back and makes a statement that, hey, I should never have been omitted, we're going to have to fight with them. And I had that happen where I was legally correct. This was a construction lien situation. I went all the way up to the highest person in the state, who we talked about it, and he agreed with my analysis. And legally, the construction company did not have a claim because we had bonded the lien off. And I'll talk about liens and clouds later on. But basically, when the construction company wasn't paid, they filed the claim of lien in the public records, making a claim against the property for the money they were owed. When that happens and you want to fight with them, you can now say, okay, the lien is for $300,000. You can put 133% of that money into the court registry in cash, or you can buy a bond, and it takes the lien, the claim that the contractor has, off the property and moves it onto the money while you fight about it. And that allows the seller to transfer the property. That's what was done. The contractor claimed, no, that's not valid because we were still fighting, and you knew our court action was still fighting, and we were racking up attorney's fees for a much higher amount fighting, and therefore our lien is higher. And the underwriter looked at the paperwork and looked at the bond and says, no, it's been bonded off, and it is no longer on the property, and you can close it. He authorized us to close it. Of course, they continued to sue, and they sued the buyer, and the underwriter wound up having to pay money. They took the risk. Yes?
Have you dealt with anything environmental that goes with the land? Any on maybe gas stations or?
All the time. You remember I made a comment about holding back the deposit until everything was fixed? We had one situation, a client was selling a car dealership, a former car dealership, I think it was vacant at the time, and their property was clean. It had been run properly and it was clean, but when the environmental inspection was done, it determined that there was a plume, which is an underground spreading of bad stuff from a dry cleaning facility up the block. Because things get into the groundwater and they move.
Were you in Miami?
No, Palm Beach. And that's it. In order to determine whether or not it actually affected our property, they had to go into the showroom. And mind you, it wasn't operating anymore. Go into the showroom and drill through the floor down into the ground to find out if there was bad stuff down there. So if the buyer is doing that in that circumstance, you got to hold the buyer's feet to the fire to fix the floor. Otherwise, you have a crater in the middle of your showroom. That's a bad thing. It's unusual, but it's a bad thing. I had a bank one time that was foreclosing on a marina, and when banks are terrified of environmental issues, they actually stopped the foreclosure and walked away because they did not want to own the marina. It was that badly polluted, the gas station stuff. And yet, modern facilities, I had one where
Probably parking
I'd have one of those too. I'll
Yeah.
hold that thought. We had another one, another car dealer, and the catch basins had, which is basically, it's a drain. You walk through a parking lot, you'll see a drain. That's where the rainwater goes. So the rainwater goes, and what happens is it goes into a hole until it fills up to a certain point, and then it drains off through pipes. Well, the catch basins were dirty, I mean environmentally dirty, in part because there was a trucking company next door that some of their stuff either came through with the rainwater or whatever. We didn't want to hold up the closing. The rest of the property was completely clean. So what we did was, we had the surveyor come and create legal descriptions of about a 3-foot perimeter around each catch basin. And we held that back from the deed. And we closed the transaction until they could get them cleaned up. Because nobody wanted to hold up the closing. Most modern facilities, like a modern car dealer, they have an oil water separator built into the catch basin. Because you think about it, a car dealership, they're washing cars, they're changing oil. The oil changes should be contained when things spill. Older vehicles drip, and then it rains, and where does it wind up? It winds up in the catch basin. The archaeological, it's great because these questions are wonderful because they bring back old stories and old examples. It was a redevelopment of a fairly prominent piece of property in downtown Miami, and I wasn't involved in the transaction, although a friend of mine who was involved was going to call me to testify about the valuation of the property. They discovered in a corner of Indian archaeological stuff, not burial, but evidence that something was there. I forgot what it was they found. This is in downtown Miami, right on the point of the Miami River. And right. Down by what they built around it is what they wound up doing. But it got held up. So the point of the reason I got involved in it was the developer had spent a lot of money to get the permits, and I'll talk in another session about zoning and land use and things like that. But they spent a lot of money to have the property entitled. Entitled means they got zoning changed from a house, or whatever was there, to a 20-story condominium building. And they went through all the expense. And the question for testimony, or they eventually settled the case, was, does that increase the value of the property? I would have to imagine it's a no-brainer for everybody, right? If you, all of a sudden you have a permit to build something, that makes the property a lot more valuable because it's done and it's approved. So, yes, archaeological counts.
So, does entitlement, or entitlements, rather, do they, assuming you have an as-of-right ability to build that condo, as you were
You
saying?
never have an as-of right. It means you're zoned for it. You then have to go back for site plan approval
Sure.
and permits. And for example, I did one recently here in Broward County. And as a condition to approving the construction of apartments, because they were trying to do smaller apartments, because that's apparently what the market is, they required us to put a restriction on the property that you couldn't have short-term rentals less than a year, because they didn't want transient use.
What does that mean?
That, like a hotel, where you could, and
What does
actually,
transient mean?
In and out.
in and out. So let's say, I'll tell you what the purpose was. You have a physician who's in training, he's in residency. What they'll do is they'll go to a particular hospital for 3 months, and they'll train in a particular specialty, and then they leave. So the client wanted to make these units available where a doctor could come in and rent it for 3 months instead of a 1-year lease, and move on, and then the next 3-month guy would come in. Well, if you think about it, the person that's going to come in there and rent that that facility for a short time, they're not going to take care of it. They're not investing in it. They're in and out kind of people, and cities don't want that. They want residents who are going to come, they're going to work there, they're going to stay there, and they're going to help the city grow, be a good city. So
So that's the city, or like the city?
the city required, as a condition of approving the development, that we record a private restriction against the title, saying that there could be no short-term rentals, which were defined as less than a year. And the client went along with it because he wanted the apartments approved.
I'm just looking like,
Less to do with the word transient, more with short-term rental.
no, but like, I
Go
don't
ahead.
understand the idea of, I guess like the approval, so like, they need to approve it, but like, why is that even like their matter? Like, if it's
Okay.
your land and if it's your building, like, why the hell does it matter if they stay for 3 months or 6 months? I understand like the context of what you just said, but like realistically, like, if I'm building it, like,
You need, okay, so
You get along with
number
that.
one, zoning. Okay, the property was a parking lot of an office building, and we were taking the parking lot of an office building and carving out a piece of it to create apartments. So we had to rezone the property in such a way that we could have residential on this site. That required city approval. Number two, there's density issues, which the density issues mean that you're only allowed to have so many whatevers, whether they're offices or dwelling units or anything on the site. We wanted more. We wanted a little more height. Their normal was 10 stories. We wanted to go 12 stories because you get more units, more rent, more value. All of this is regulated by the government, by the local governments. It's part of zoning and land use to keep, so that when you go down the street, you'll see house, 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 not house, warehouse, office building. You know, you want to keep everything the way, developing in the right direction. That's why. That's why. So you, as much as you think it should be your free right to do whatever you want, it's not. Comply. In fact, even if you look at even the stuff in the contract that talks about the title, what it's subject to, where I talked about restrictions and other things, it specifically says that the title will be subject to existing zoning and governmental regulations. But it has to be. And this is how it is, because if you want, residential is a perfect example. You want to live in an area that's residential. You don't want to be living with a factory as your next door neighbor. That's going to wake you up at 3 in the morning because they're using machinery.
gotcha.
The only way to do that is through land use.
So with the entitlements? Because you hear that thrown around, and please excuse my ignorance on it, but whenever, you know, you're getting a parcel entitled, and then you sell that entitlement, is the strategy to grab an options contract?
No. You're mixing concepts up. Entitlements is a fancy word for approvals. That's all it is.
Ah,
That's all it is. So what's happening is, you have a piece of property that's a big piece of vacant land and it's zoned for agricultural, good one. And you want to build 100 houses on it. So now you're going to go and you're going to get approval for it. Now that this piece of property has been approved for 100 houses, it's worth a lot more than it is for 100 cows.
sure, and but is it a developer's agreement that you're selling?
No. You changed the city's zoning as to what that land can be used for. There's more steps to it, but
They have a zoning map.
The code or rezone? An amendment to the code, or is it being rezoned?
both. It depends.
Okay.
The project I was talking about, we did both because they created a whole new zoning category for a corridor of a particular part of the city.
Got
And
it.
sometimes the language for what you like want to plan, there's something in the zoning code too, so there's like please.
Okay, so I want to, we've gone through the contract pretty much, which I knew I was going to have a challenge stretching this contract for the full amount of time, but I do want to have a conversation about something because I'm a little bit of a loss as to how to administer something, and I'm open to suggestions. Short of name tags or assigned seats, one of the things I want to be able to do is to have a little bit of evaluation of participation. because that's, well, that's not a major part. I think they put in the syllabus like 10% or something like that. And I think it's an important thing to, but I don't know what to do about that. I mean, I can do that too. And I didn't say, you know, here, I have a list, but it's kind of,
You could do like little interaction things.
well, there was something else I thought about as well.
Or a discussion board
Well, like
online,
that's fine.
you wanna
Just
do
make
that?
I know I discussed with you about
He wants to know if you have a class list.
He's texting
Yeah.
you?
Yeah, he texted
I do.
Oh, that's a good one.
No, a lot of,
It was
a lot
online.
of things have been happening behind the scenes.
And so,
You have to make sure.
Like you said, people now, it's very-
why?
I'm like trying to do it.
So I guess,
I'll bring you back to like, so like, I don't
no, because you and I talked about as to whether I should do that.
accept that. What you
Did you
did,
take
you
all
go
of
back
the
to
passages
school and those songs were good.
in order to do the roster reconciliation for people not present in an
Okay, that's easy. If you're not present, would you raise your hand, please?
And then I was like, I mean, you think something, I'm fine.
I mean, I can,
I'm still physically here.
Yeah, I don't have to do it. So it's worth it through. Yeah,
I can roll call, but
So that was-
that requires pronunciation too, and that's what it's.
No, I knew it's
Which would be easy, except whoever the first name is the hardest one to pronounce. All right, so you're guilty and you're here. And say it for me. That's, I would have said it just like that. No, seriously.
So I have business administration and.
All right, let me do this, because that way we're satisfied. Barbara?
I didn't feel like an interview.
Thank you.
It was like, I really
Brandon Bell.
Or I could do the same thing. Yeah, I said I could do something that I absolutely like know
Renaud?
much about. And that's more like, I don't
Where?
care about the degree, but like,
Bianca?
Blanca. I go by Maylee.
Is it Blanca?
Yes.
No, it's not on here, it's
Well,
a
wait,
different
I'm asking
I.
someone else. Just kidding.
Usually all the way to the end, but then
Just kidding.
so what did you do?
Seriously, what's your last name?
My last name's Vieira.
No.
Okay.
But I'm gonna check you off because you're here. James Carter? Here.
At your house,
Isabel Charles? Alex Cohn? Brian D'Souza?
And you drive, I'm sure. And how with me, bro? I'm even like,
Leon, I met you.
I don't know, anytime I gotta go.
Bruce Clement? Chase Gajewski?
Here.
Did I do that right?
Diet.
Cynthia Garcia?
The only time I ever go to is
Christina Gibbons? Christina?
Yeah.
She was here.
She didn't raise her hand.
Yeah. How long have you working for?
Dana Hines?
Oh, okay, so it's relatively.
Nathan Johnson?
Where did you get that?
Ryan?
Yes.
So like, you're in between that and.
Erin Ladd?
Okay.
Adriana Manqua? Juliana Odman?
That's it.
Michael Oshman?
Yeah. A lot of my friends.
Angelo Palomino?
They really easy to up when it comes to.
Rogelio?
I mean, obviously, like, there's a lot of ups and downs to everything, so like, shit.
Amy Rundon?
Getting education paid for it, like,
Amy?
yeah.
Marilyn Sweetie?
There's a lot of that.
Andrew Steiner? Alana Stewart? And Olson Thomas Wolf?
Osland.
Oh, sorry.
Oz, that's okay, just Oz.
Okay, that's helpful.
Yeah, very typical. Like, computer obviously, I have to scale up.
Did you get
So,
me?
I was like,
I did.
Okay.
Because I found you, you were actually, you told me where it was and I looked.
Thank you.
degree, and then going in, like, getting jobs. So, like, I was like, 5 years, and have
Well, I'm not one to stick, I mean, today anyway, particularly, if to sit here and try and bore you for another 20 minutes, so.
You don't have to.
I know that, but I'm open for questions, except for you.
What firm are you with? Do you have your own practice or?
I'll answer that in a second.
What about like dates, like midterm, final, syllabus? You don't, is that up for discussion there?
No, okay, so, without being too simplistic, I guess the midterm would be in the middle, the final would be at the end. Yeah. And I don't, no, it's a good, I thought, it's a good question though. Is it? And, you know, I don't think we're gonna take the entire 4 hours to do an exam. So we'll probably start with the, I don't know. No, you should, it's a good question, I don't know.
Are your exams go over in class, or we have to go on the things that
Most of them are going to go in class. But let me talk, that's a good question. The textbook, as I went through the textbook's got a lot of detailed material on each topic that I'm going over. Some of it's really boring. And I'm not going to sit here, you know, if you want to learn about accretion and avulsion, and what is that? Is a bad example I could possibly come up with. If you want to learn about really technical legal, super technical legal concepts that are not practical, then go next to the next building, please. This is the concept. The concept here is to discuss real estate law from a business standpoint, which is why I started off with the contract analysis, because it's really the best overview I could come up with to go over the really important principles and to tell you, and to lead into other things, which hopefully I put in the syllabus some of the other things that I'm going to go into in much more detail and different aspects. But I'm trying to stay practical within the real estate law and use the book for background material. Like for example, let me see what I said. I'll stretch that out. It's surprising what you can come up with within topics. It's amazing in going through the contract with you and just seeing like those little parentheticals and all the stuff that I can expand on the parentheticals. So are we all okay with working from a document as a basis? Okay, good. That's helpful.
Yeah, sure.
So what I'll probably do is, and I do promise to, they do promise, we're supposed to be in another room. Hopefully they'll let us know before next week. I will go, I'll bring more documents and we'll go, like for example, if I'm talking about financing and things, some examples of notes and mortgages and other financing related documents. They're boring as hell, but they'll go through the principles of the loan documents and just put you right to sleep. But the principles that you'll get out of them are into the real estate law and why each section of each document, just like the contract, each section of the document has a specific meaning. So that's what I'm intending to do. But you can also go into the textbook and find more detail about things to the extent you want. But no, the question, it's a good question. Most of what I'm going to try and test on is going to be based upon what we're talking about. You know, because this is the subject matter. That's background. I mean, there may be principles in there that are going to show up because it's important. I mean, I talked about offer and acceptance, to take this piece of paper and turn it from a form into a contract. So you may find more detail about offer and acceptance there. I'm not going to go dig through the textbook and find the minutia, the worst possible question I can find on offer and acceptance, and do that.
Will you give us a study guide?
What would you want in the study guide?
The answers.
Like an out, I mean, obviously, like, we cover a lot of topics, but like 4G, like, he has the precise, like, topics that we're, like, covered, and then we just know exactly what.
But he's a real
This is
professional.
the last one.
There you go.
Because like the program, like,
I'm just
the thing
doing this for fun.
What? the
Seriously,
usual kind of-
I will get the email working. I
So I
don't know how to
far
do it.
behind.
What my devices so I don't come on. If you do have specific questions that are within the scope, I will be happy to answer them. You asked a question, I am with a big law firm, it's called Great Split
And
Market.
that's the first thing, using like the financial calculator.
Oh, you did land use with that?
Well, what are the whys?
You what?
I'm putting together the computer this,
Oh,
it's actually just fun.
Tyler?
Yeah, it wasn't really called it yet. It wasn't only like, yeah, but I didn't like, it wasn't like the most. Yeah, but it wasn't like, it was just like nothing like crazy, like after I left finance, like, yeah, like, just the basics of prior, and like, some options, but I didn't feel any more depth in like financial fucking analysis with like.
No, he's not prior. He's a professor here.
Oh, okay.
And also,
Yeah, I used to sell every day, but more like inventory basis. Like for all like the
Any other, I do attendance, validate my attendance, which
You want to know if you wanted a new classroom, I said you wanted a new technology for the document reader, they have one of the most.
Well, you and I talked about it. The concept was, I didn't think I was going to be able to stand before I was like, part of the issue about moving the classroom was that these are miserably uncomfortable desks versus, I guess, what the others are, the comfy chairs.
yeah, we weren't being stuck up.
And then
It's
there's also like power strips, if you might just plug in every device.
Well, it's like one of the things that I had was, I have a survey. I was going to put the survey under it, but I'll deal with that later on. You know, legal descriptions and things like that, because I believe the graphics and being able to see what I'm talking about are probably much more helpful, I hope.
Old newspaper articles, anything. It's in 1958 math with Broward, that would be.
Oh, that would be.
That would be great.
I want to say that.
I thought there was no more in the 70s and 90s.
Well, university tribes only created
When's redevelopment time for this area right here? So the retail, students walking, it's just not walkable over here. I'm just waiting for redevelopment. Well, it's a little above us, like a little walking.
It can be affiliated.
Somewhere residential.
It doesn't feel like a campus. Yeah, right.
This started as community school. Big time.
Community school.
Not community, community.
You might get like 700, but you're not getting a lot of.
Okay, again, any questions up here for a little bit, I'll stay, but basically, again, not being a clock watcher, 4:15, go, this Saturday.
You missed it. You know Mike Oshman too?
Yeah, man.
Who's the man? Two M's or one?
Yeah, I mean, he'll talk to you more about like what underwriting means. Then I told
I'm gonna take my.
it's analysis, it's
Question, like,
it's
I
analysis of underwriting.
knew
It's
it all.
analysis of the asset and the market.
I knew it stopped when I
So
was
you
happy about
have
that.
loans between $1 and $5 million average. So the property is goes under the foreclosed on numbers, you can go after the loss and their assets. Gotcha. Usually commercial dudes, non-recourse. That's why we